My name is Nicola Lewis. I'm an intermediary and I've been doing that job for approximately 10 years now. Essentially, we help people with communication impairments to understand what's going on in the justice process that they're involved in, and also to be understood. So it's about being able to understand the process in court. It's being able to understand their solicitors and their barristers, to be able to give instructions, and also to be able to express themselves, so to be able to give their evidence in court. So understanding is a massive difficulty. And also when vulnerable people give their evidence, there's also the ability of the justice professionals to tailor their communication to the needs of the vulnerable person. So I think it was Baroness Hale who said that it's for justice professionals, it's for the justice system to adapt to vulnerable people, not the other way around. What I would say is that masking is a very common phenomenon in the family courts for people with learning disabilities. They will build their understanding of a word around the words that they do understand and fill in gaps. And that can lead to people acting as if they understand a question when they've got no idea. They're just propping up their understanding by linking into words that they do know, but potentially completely misunderstanding the word that they don't. And sometimes people with learning disabilities can have issues with focus and concentration. And what that means is they won't be able to sit from 10 a.m. to 4 p.m. with a very large cognitive overload of information coming towards them visually, verbally, in documents. And they may need breaks and they may need shorter court days. The other really fundamental point is trauma. Trauma naturally is going to play a part where parents are going to be asked to talk about things in their past or talk about events which have occurred concerning their children. And quite often they will be placed back in the moment in court. And those who understand trauma and trauma-informed practice understand that that leads to certain parts of the brain and certain parts of communication to go offline. Some parts of memory retrieval go offline. Some parts of functional communication can go offline. And without a fundamental understanding of those issues, parents with learning disabilities can be severely disadvantaged in court when giving their evidence and when trying to understand the process before them. There is a real issue that intermediaries or communication support to the level required is just not available pre-proceedings. That pre-proceedings, quite often, there's a breakdown in communication between the parent with the learning disability and the team that's trying to get them back on track and trying to even just to get across to them the importance of taking steps at that point before the matter escalates and goes to court. And it seems a very easy win from our perspective to have the right level of communication support. Interventions that could usefully have happened earlier on in the proceedings with the right level of understanding as to what they are, why they are being recommended, and what the consequences are. If that information could be delivered in the pre-proceedings time, then from my perspective, far fewer cases would end up where they do. I've been doing the job for 10 years. I've only ever been invited once to assist pre-proceedings. So what do I actually do as an intermediary? I will help the parent to understand the court documentation. Sometimes that will be with solicitors in meetings in advance of the court hearing. Quite often it will be at the start of each court day. We will review the evidence that's going to be presented, sometimes to refresh their memories as to what the issues are. Who the various individuals are. We might look at what their roles are and understanding basically what's going on. So understanding court documentation, understanding the potential outcomes and their effect on the parent. And again, concepts like parental responsibility, PR, I would say maybe in 10% of the cases I've worked with parents with learning disabilities, have they actually understood what parental responsibility is and what it means. So we will work very hard to explain what the potential outcomes are and their effect on the parents' parental responsibility and their ability to continue seeing their children in the short, medium, longer term. Then back in court, we will help the vulnerable person to understand the evidence being presented live in court in the moment, quite often literally simplifying in real time what's going on. Also, in court, an intermediary will assist the vulnerable person to give their evidence. This often breaks down into two parts, really. One is we can assist the lawyers in tempering their questions so that it meets the communication needs of the vulnerable person. Again, all tailored to the vulnerability of that specific person. There is no generic person with a learning disability. There are people with strengths and weaknesses. We also assist the vulnerable person to instruct their lawyer. So there are conferences obviously outside the physical courtroom, which are often as important as what goes on in the courtroom itself. A lot of the negotiations and discussions need to be explained, and the person with the learning disability needs to be able to tell their lawyer what they want to happen. Finally, there's judgment. It's obviously key that the person with learning disabilities is able to understand that the decision that the judge has made. And often we will recommend that the judge gives their decision first and then all the reasons follow. Again, quite often people with learning disabilities may have problems with retention. And the last thing you want is for somebody to have been so overwhelmed in the moment that they leave court and then they can't actually remember the reasons why their children were removed from their care. For me, from my perspective, a positive outcome is effective participation and equal access, fair access to justice. To my mind, a positive outcome for a parent is being able to take part in a process, being able to understand what the reasons are that there are worries and concerns, being able to understand what needs to happen for you to be able to keep your child in your care, and being able to understand what the decision is